Okay, I have no idea what I'm doing at all, but let's just have a quick look through at the changes to employment law for this and a little hint of what's coming next year that might actually help working people. Because I've seen a lot of people sending around memes going, oh, it's all this. No, it's not as good as it looks. It's not as bad as it could be. So let's do it properly. Now, minimum wage is going to actually be split into two different sections. There is the £11 whatever one that we've got at the moment. Anyone working is able to qualify for that, as long as in the UK. There's a new one. It is the maximum minimum wage, and that you need to be in the UK and you've got to be over 21. So they're still splitting it by age. That's still stupid. It just is. I'd rather folk were making £12.71 if they're all doing the same work. Everyone needs a roof over their head, all that. Now then, when it comes to work time, if you're an employer, you've got to decide the hours, you've got to be honest about them, and you have to say what can and cannot be done during that time. It cannot just be vocalised. You've got to write it down. That's what the contract's for. People should not be doing what is not in their contract, and that goes both ways. So if there is a breach, say you ask an employee to do something that isn't in the contract, then you're responsible for that breach. If you breach their time, you're responsible for that breach. All employees, regardless of time that they're working, need to have rest break and should be a set amount of time. So we're being quite strict with that now. It's for the betterment of the workforce in general. If you're working, especially if you've just started working and you're not sure what you do, see if there's a union. Employers will have to start telling people that they have the right to join or create a union now. Good thing. If you are an employee and you are getting paid more than $10,000 a year, you should be auto-enrolled into pension payments, and you should get paperwork that states that. If you do not, you go and demand it. It is your pension. If you are making over £6,240, it is up to you if you want to be enrolled. Now, there is an opt-out option. If you have a private pension, anything like that, it is very difficult to enforce and demand. If you already have a pension that's doing a good rate for you, it's worth moving. But if you go for the auto-enrolled pension, basically you have to put 5% of your wage into that pension pot for labour. Your employers need to add 3%. That is the legal minimum. Some may offer more, but 3% is the legal minimum that they have got to put in. If you are over £6,240 and you are enrolled into an auto-enroll pension scheme. Non-eligible workers can still ask to be put into the scheme, but you will still lose your 5%, and that will go into your pot. So it's not really a loss, it's for later, which isn't much use right now. But employers then don't have to provide the 3%. I don't think it's the best scheme. There are better ways of doing it. There are fairer ways of doing it. But it is at least an option, and you should know that they owe you that 3%. Do not let them get away with that. I've seen it plenty. I do a lot of work in the Parish Council, and we get so many complaints about things like this. So remember, if you're over 10k, you're auto-enrolled. If you're over 6,240, you can be enrolled if you want. There is an opt-out option. You can tell I'm not used to this. 5% goes into your pension pot. 3% must come from your employer unless you are making less. than £6,240. Just silly. You'd think it would really be the other way around. Now, there are some changes for work regarding the Equality Act 2010 and the update for this year, which is the Employment Rights Bill. Now, it was already unlawful to discriminate due to disability, race, gender, sexuality, religion, or belief. You do not have to prove that the discrimination has caused you upset or harm. The act itself is called direct discrimination. It is also unlawful to indirectly discriminate for the same reasons if it is unintentional, but the impact is felt. So, for example, a lack of flexi breaks for someone who is disabled, or a religious worker, or someone with children. That is indirect discrimination. So, there's a few things there. Any employer who is putting a number of years of experience in a job description, they're actually falling foul of the ACAS Code of Practice and the GDPR. I would apply anyway, because the years of experience is usually very stupid. It's a dumb way of looking at it. What you want, preferably if you're an employer, use the term substantial experience instead. Now, the Employment Rights Bill 2026 came in force 18th of February this year. Basically, most of what is in there involves trade unions and the increased protections to ballot. There are better protections for strike action and trade union growth now, which the government's feeling a little bit stupid for doing with what's happening with the doctors, but that's also their own fault. Things such as statutory sick pay, paternity pay, and unpaid parental leave. These will now be available from day one. They're the day one employment rights actions. Sexual harassment has now become a legal necessity for disclosure. Now, this is specifically under whistleblowing laws. So there is protection for not only the person who has been sexually harassed and has brought it up, but also if someone else has actually had to whistleblow on their behalf. So there's protection there. Gender protections such as the gender pay gap, so repairs for menopause, men's increased risk to prostate cancers, all sorts of different things come under that. They've actually been put off for a year, which I think is a bit silly, because it's been proven when that gap is sorted between, it's not even between men and women, it's just for these particular conditions and issues. It brings more money in locally, so the overall economy ends up much better. But they've put it off until next year, where it will be looked at again. So that is the state of that now. Fire and rehire, now against the law. So dismissing an employee if they have refused what is classed as a detrimental effect from a contract change. If they are fired, if you are fired, or if you fire someone because they will not do a worse contract, that is now classed as automatically unfair. It is a legal standpoint. If something is unfair in regards to work law, it needs to fit a very, very narrow set of basically ticking boxes. It's got to be these particular things. That is now automatically unfair. There is no arguing in regard to it. Tribunal claims have extended time to run. So rather than them having to be done within 3 months, they must be done within 6. Now, this is great for people who don't have any representation and need it. It gives you a bit more time. If it's a complex case, it's not getting rushed through as much. That's a good thing. The suggested time for starting a tribunal claim is still within 5 days, which is the ACAS standard. So if you have issues, get them moving quick. Also, employers must now inform employees of their right to join a union. If they do not, there's not really, they're not, well, they are breaking the law, kind of. It's more they're going against best practice, but that law doesn't actually have any punishment whatsoever, so it's not really a law. But they are to inform employees their right to join a union. We, as a parish council, we inform our employees, you have the right to be part of a union, you have the right to form a union. So that is very standard. One really good thing, which I'm hoping will basically bully particularly big companies that mistreat their employees into being a little bit more, well behaved. The compensation cap. If you are unfairly dismissed, I do not like this, but it needs to be done. Someone's got to do it. So the compensation cap has gone. If you are unfairly dismissed, you can then claim compensation. You can take them through tribunal, and the tribunal will decide. If they do not decide in your favour, you still have the right to appeal. But before, the compensation was very low. For example, one place I worked, the boss did not like this particular woman and bullied her so badly she lost her baby. The total she came out with was £10,000. Yeah, that's not really anywhere near enough at all. So that compensation cap, gone. It's just gone. If you will not look after your staff, expect to be punished for it, which is the way it should be. Now, I've seen a lot of people pop up with the idea that protections, everyone gets protections immediately. No, you actually don't. Unfortunately, the only ones that are from day one are statutory sick pay, paternity, and unpaid parental leave. That's it. The remaining protections, what would normally take between 1 to 2 years to kick in, will take 6 months. And that is not until the 1st of January next year, by which point it would not surprise me if they've changed that again. So don't get your hopes up, but try to be aware. It is a concern. Now, there are some possible changes for 2027, which could be very, very useful for a lot of people if they go ahead. If is doing a lot of lifting here, unfortunately. So, one thing we definitely know they're wanting to put in, and it looks like it's 100%, when flexible work or break time requests are made, if an employer chooses to refuse to allow these flexible changes, they must provide in writing a fully fleshed out reason about the refusal. And it must stay within the law. It can't just be, oh, well, I didn't feel like it was, like, no one cares about your feelings. It must be within the law, it must be logical, and it must make sense. To be absolutely blunt, your free fees do not count in regard to employment law. They truly don't. So that is one thing that looks like it's definitely going to be coming in. That will help a lot of people who have kids to pick up and get the childcare. It will help a lot of people who have sick family members who need help do have a massive epidemic of cancer in the country at the moment, and it is going to get worse as climate change kicks in. There's a lot going on. Now, one of the things I think would be very helpful, which you have not confirmed and is likely going to end up on the scrap heap, they have been suggesting a statutory bereavement leave. Now, this is something that keeps on coming back and coming back and coming back, and it never actually gets anywhere. This is the closest we've got to it, and they still haven't confirmed it. And the proposal is a little bit garbage, I'll be honest. The suggestion is a statutory bereavement leave, which is just 1 week. It would be a limited pay, but it would include if you lost a pregnancy or a child. Personally, I would think that perhaps you would need more than 1 week. But again, the government have not yet confirmed this. The confirmation for whether or not it's going ahead should be the 1st of January 2027. If it does, it will likely not kick in until the April for the tax year. So that is something that may also be occurring. Now, there's a few other bits that are coming on. Most of them aren't actually that useful, but there are some bits which are very standard and should be dealt with regardless. Specifically, I'll next be getting into grievances and also misconduct and gross misconduct, different things. Just so you have an idea of what you need, what will happen, how to deal with this when it turns up at work, whether you're the employer or the employee. They're all important. And I also want to look at restructures and redundancies, as that is becoming a bigger and bigger issue at the moment. We are having serious problems with restructuring and redundancies that are not falling within the law, but are also deeply, deeply harmful to the people who are being let basically over a cliff. But that will be the next one. Loads of fun. Okay, toodle pip. I don't know what to do.